Section 20 of the Prevention of Electronic Crimes Act 2016 colloquially was referred to as the criminal defamation section. And since 2017, this has been used in FIRs against journalists to charge them for remarks about state institutions. Now, Section 20 was one section of the law, among others, that was vehemently objected to and opposed. Clearly, for this reason, that it would be used to target dissidents, because the language was very vague. So at the time said harm to reputation, false information. Now, when you look at the language of the law, and our legislators at that time said that one safeguard was going to be that it is non-cognizable, which means that you can't directly register an FIR. And so procedure requires that if the FIA receives a complaint, it will approach the magistrate, get the requisite permission, and then proceed the investigation. We've seen that this has not happened because Section 20 gets used with other cognizable sections of the law, not only PECA, and FIRs are registered. So since 2017, we've been seeing that Section 20 crops up against journalists, and sometimes these are just remarks. This is critique, and the language of the law does not cover the state or state institutions as a complainant. The complainant must be an aggrieved party, it must be a natural person. All of these things over the years have been established in various cases. And what's important is that the Islamabad High Court struck down the harm to reputation part of this law, along with the ordinance that sought to expand the ambit of Section 20 to include state institutions and functionaries as complainants. So that was done away with. However, despite that, FIR, and we saw that the recent FIR invoked Section 20. Clearly, these cases have a chilling effect because the person is made out to be an example. Once a case is registered against you, you have to go through the motions of the law. You either seek pre-arrest bail if you've not been arrested, or picked up if you have been. And I say picked up because oftentimes what tends to happen is that it's an abduction of sorts when the person is taken from their residence or elsewhere. And then the formal charges follow once they are already in custody. Then they have to apply for post-arrest bail. Meanwhile, their devices have been taken. Sometimes they are compelled to provide passwords so that there is access to their devices and social media accounts. Now, even as per law, the law lays down requirements for warrants, Section 33 of PECA, Section 34 of PECA, but we know that this is not followed. And so it's circumvented by gaining powers to arrest through other sections of the law. Once they are, and then of course they have to go through the motions of the law. So beyond bail is going to be then investigation, joining the investigation, giving your statement, appearing for all the hearings. As an accused, you're required to appear at every single hearing. And this can go on for weeks, months, and years. It depends. Some journalists are still facing cases under PECA that were registered some years ago.